Good morning, ladies and gentlemen. I think it's about time to start. If you could just take your seats. Thank you. Good morning. My name is Piet Eekhout. I'm a professor of EU law at University College London. That is still being tolerated in that lovely country. And it's a great pleasure to chair this session this morning. I am chairing with a small disclaimer, and I hope Chiara will forgive me for mentioning this. I tend to hold myself out as a rather generalist EU lawyer. And the disadvantage of doing that is that one may receive an email from a conference organizer 1 week before the conference with the question whether I'm willing to chair a session here, given my expertise. And yes, I can say things about extraterritoriality, about autonomy, mutual recognition, equivalence, but I had better keep silent about banking supervision and the EMIR regime. But we have a wonderful cast of speakers to say something about that. And I will definitely learn a lot. So by way of introduction, I should like to try to pick up some threads from our wonderful, fascinating discussions yesterday. And first, perhaps on the question which is a little bit at the heart of this conference, namely whether the growing autonomy, the developing autonomy of EU law and of the European Union is compatible with the rule of law and is compatible with multilateralism. Compatible with the rule of law, it must be. And that's not just in light of the impassioned speech and pleadings by Susanne Baer, which we heard yesterday, which I fully subscribe to, but also quite simply because the EU is a community of law. It doesn't exist in any other form and can only project the power it has through law. So I think I would answer that question definitely affirmatively. Multilateralism is a bit of a different discussion, of course, more of a contingent one, which really depends on the times we are living. It's one thing for the European Union to support multilateralism, but on its own, it cannot, of course, build multilateralism. It needs cooperation from other states. And if states are unwilling, which many seem to be these days, multilateralism is not so easy to pursue. At any rate, I think, and my speakers may correct me if they disagree, but in the field of financial services, there's never been really any strong multilateralism. I'm thinking again of my early days doing research in EU law, where I looked at the single market at the time of also the Uruguay round, and we had the GATS being developed. But I was kind of wondering, now forewarning, of course, but I was kind of wondering whether any of my speakers would mention the GATS. I don't think, other than on paper, certainly in financial services, it means very much, and also in other areas. But on the general question, I certainly do think that building the EU's autonomy and multilateralism are not mutually exclusive. In this panel, we will look more closely at some key concepts which play an important role in these debates about autonomy and the EU's relationship to the rest of the world: extraterritoriality, equivalence, mutual recognition. I leave this to the speakers, but it would be great if they could connect these concepts as applied in their respective fields to this question of autonomy. And I suppose I, for one, would ask about their views, and I haven't warned them about this, so you can scribble and whatever. Ask their views on whether the growing EU autonomy is one which fundamentally enables the EU to cooperate better with other countries where that's possible, or whether it's an autonomy which is more inward-looking, which is, if you use trade terms, perhaps a little bit more protectionist, which focuses on what we can do inside rather than with others. But that's about all I can say by way of introduction. I think we have a great panel. On my right is, furthest right is Professor Matthias Lehmann, who's University of Vienna. On my closer right is Maria Rafaela Aceta, who is head of international affairs at FISMA, the European Commission. And on my left is George Johnston, who is Deputy General Counsel of the Bank of England. And they will speak in the order as on the program, so from right to left, and there are no political implications with that at all. So Matthias, 15, 20 minutes maximum, please. Thank you.
Thank you very much, Pete, for the kind words, and congratulations having made it past the security check. And thanks for the effort of coming here at 9 o'clock in the morning, or trying to be at 9 o'clock at least. I hope I'm going to make it worthwhile. So extraterritoriality, equivalence, and mutual recognition, a lot of words. We have to clarify the terminology a bit, I'm afraid. Then we will think about which of these three tools, I think of them as tools, in the toolkit of the supervisor, which of them is the best in the era that we live in, that has been so eloquently described yesterday by Professor Baer. And finally, I'm going to focus on equivalence, which I think is the best tool, spoiler here already, and examine a little bit how this can be used in a political context. So extraterritoriality, you may think you know what extraterritoriality is, but it's actually a quite ambiguous notion. That is because if I give you an example, here we have what you probably would think is a typical example of extraterritoriality, where you have the supervisory authority of country A who gives orders and tries to supervise and regulate also a service provider in country B. Seems to be like a straightforward case of a country applying its rules beyond its borders. But we can think of the same case also differently. We can think of it from the perspective of country A. Here is a service provider from another country who enters our market and who wants to offer products and services on our market. So this is actually a domestic case because we are regulating our own market, access to our market. And in this sense, the same case can be thought of as territorial. Why is that? Why is there this ambiguity? Because it depends on how you define, of course, territory. And we know what territory is, the four corners of a state, but what we actually mean when we say territorially or extraterritorially, we mean a certain link to this territory, something that has to happen in this territory. And now it depends very much on what has to happen in this territory. Is it that an activity takes place in this territory, or is it that some provider is located there? And that makes it so difficult to exactly define what extraterritoriality is. I always say I know it when I see it. Second point, we always think of extraterritoriality with a little bit of a negative connotation. It's a connotation. It always seems like that's not good, right? Some think it's against public international law, but it's not. The Permanent Court of International Justice has decided, a very old case, Lotus, it's not violating public international law if you prescribe conduct from your territory that takes place in another territory, or if you adjudicate a case that took place in another country. The only thing that is really prescribed by international law is the use of force in the territory of another state. Now, the International Court of Justice later has backtracked a little bit and has said, okay, we need a genuine connection to your country in order to regulate or supervise from this country or adjudicate a case. Now, here is the point. In the world that we live in, everything is connected to everything. You can see on the slide, I'm just giving you some connections between financial centers in the world. You see a high level of connectivity, and what happens on the other side of the world can have huge repercussions on our territory. So basically, extraterritoriality is not legally prohibited, it's not morally reprehensible, and it's even a necessity in the world that we live in. And it's not a coincidence that the EU has also used extraterritoriality more and more. Okay, we come to equivalence and mutual recognition. I will treat these two first together because they have a similar function, and that function is to somehow alleviate the strictures and costs of extraterritoriality. Because if you think of it from the point of view of a service provider, due to extraterritoriality, the service provider has to respect the laws of two jurisdictions and also is supervised by two jurisdictions if it wants to offer services and products in two jurisdictions, right? So you have double regulation, double supervision. And what equivalence and mutual recognition do is country A just says, okay, the regulatory and supervisory framework of country B is achieving basically the same goals as ours. So we accept that this service provider is regulated and supervised in country B, and we don't impose our own rules and our own supervision. So it takes away this double burden of double regulation and double supervision. And this is even more important if you think of service providers that operate in more than two countries, maybe even around the world. For them, it would mean they have to comply with all of these rules and are supervised in so many countries. And this, if everybody would use equivalence and mutual recognition, we would simply have one regulator and supervisor. So that is the common point. Both of them imply that the country where the market is defers to the rule of the home country of the service provider and says, we are not going to apply our own rules and we are not going to impose our own supervision. Basically, it's a home. Both of them imply that the home country is responsible for regulating and supervising the provider. But here come the differences. Already the legal basis. The legal basis for equivalence is always in national law. So it's the national law that decides is something and is the supervisory or regulatory framework of another country comparable to our own. And in the case of mutual recognition, this is usually by an international agreement, be it a binding treaty or be it a non-binding memorandum of understanding. More importantly, even perhaps, equivalence is a unilateral decision, right? Pete just mentioned in finance, not much is multilateral. Equivalence is unilateral. The state decides, okay, this other state, we like their framework. It achieves basically the same goals, and we accept it as equivalent, or as the Americans say, substituted compliant. Whereas mutual recognition is agreed in a binding treaty and is always bi or multilateral, which implies finally that equivalence can be withdrawn or suspended quite easily, whereas trying to stop mutual recognition is very difficult. If you remember when the EU tried to suspend the rights of Poland, that was a very difficult process, and it never led to a rupture in the mutual recognition of companies that come from Poland. So very difficult to unravel mutual recognition once it's in place. So which tool is now preferable in the era that we live in? And as Susanne Baer has shown yesterday, it's, and also Christine Lagarde, it's an era that is marked by huge uncertainty. So what to do, which of these tools is the best? And here I think we have to look at these tools more broadly. They're actually more than just mutual recognition, equivalence, and extraterritoriality. There are also location requirements and other requirements that the regulator or supervisor may impose. So the toolkit is actually quite large. And I suggest to look at those tools and order them a little bit like tools on a sliding scale. And The best for open markets is, of course, mutual recognition, as we have, for instance, in the EU. And let me remind you of the benefits of open markets. It means wider investor or depositor choice. It also means stronger competition, and it means the possibility to diversification, which increases the stability of the market. So it's actually a very good thing if you can have a mutual recognition regime. Equivalence is already a little bit, you're closing the market already a little bit because you can take it away unilaterally. Extraterritoriality, well, you still allow companies into your market, but only on the condition that they comply with all of your rules, which may be quite burdensome for them. So you're closing the market a little bit. And then we have location requirements, as we can find them, for instance, now in CRD 6, where you actually close the market already pretty much. And then you can even double down on this and impose additional requirements. For instance, you require the branch that is located in your jurisdiction also to be to have certain amounts of own funds, or you prohibit the provision of services in your region or country altogether by foreign providers, as it is, for instance, foreseen in the European markets infrastructure regulation for significant clearing services. So this possibility is foreseen but has not been used yet. Of all those tools, I think in the era that we live in, equivalence is best. Mutual recognition is ideally the best, I would say, but because it is legally certain, it cannot be withdrawn, and it has these high economic benefits of open markets, but it also creates this lock-in effect. You can hardly exit it once you have entered it. Extraterritoriality is the safest of these three, because you don't run basically any risk. You impose the full gamut of your rules and your full supervision, but it has high economic costs for the service providers, and they may shun your jurisdiction. So equivalence, I think, is the sweet spot in this, because it opens up the market and at the same time reduces the economic costs for foreign service providers, but it also has these safeguards for stability because you can withdraw it at any time. In the words of Christine Lagarde yesterday, it's the ideal combination between autonomy and cooperation, because you cooperate with others, but you retain the autonomy to break off this relation when it no longer fits your interests. So that's why I'm going to focus finally on the use of equivalence and how it should be used. And here, I think an important point is that equivalence should not be used in a political way. You should not try to punish other countries by denying equivalence. Why? Because you should not only trade with your family and friends, right? Trading is something that should be done regardless of the political relations. And that is because it can be mutually beneficial for both. Of course, there are limits, right? If you are in a war or in a warlike state with some other country, you will not continue to trade with this. But this is a decision that has to be taken by the highest political instances and not by the regulator. The regulator should focus on the conditions, the legally set down conditions for equivalence, and grant it. Sometimes this may require to also look at the political situation in the other state. For instance, do they abide by the rule of law? But you should not judge and say, well, this is an autocracy and we're not granting them for this reason alone equivalence. And you may say now, well, that creates a risk, no, doesn't it? Because if we grant equivalence, then we may be disappointed because the other country may develop suddenly in a direction which we have not foreseen and that we have not wished for. And as we have seen last time, this can happen very quickly. And here I use some simplified game theory to show you that this is actually not something that we should worry about too much. It's true that if we grant equivalence and the third state diverges from the EU standard, then it seems like, okay, the third state has won because they are actually not respecting our standards and still have market access. But this game is played in various rounds. In the next round, we will deny equivalence, of course, and we will both lose. And I may say perhaps the third state loses a bit more if the EU market is bigger than their market. And in a third state, hopefully, the third state learns something about this, right? So even autocracies may learn in the long run, and they may learn that in order to enter the market, again, they need to comply or need to approach our standards. And then in this situation, we will get them to the optimal state where we want to have them. So to sum up, I think in this area that we live in, equivalence is the best tool. And it should be used strategically to entice convergence by third states to EU standards. Thank you very much.
Thank you very much, Matthias, for a very clear and concise analysis of these key concepts. Maria, over to you.
Thank you very much. Good morning, everyone. It's a real honor to address this audience today on topics which are more than ever central to the way the EU engages with the rest of the world, and that are at the intersection between EU single market law and foreign policy. So it's a really an interesting discussion. As you know, for decades, the European integration has been mainly about building the EU single rule book, promoting supervisory convergence and ensuring the resilience of our financial institution. With the financial crisis, we have consolidated that agenda, and we have also learned that we need to manage the external dimension. We have learned more than ever that we are vulnerable if we are dependent on third countries. And that's why since then, there has been an increasing focus on managing the international dimension of the single market. Just if I'm a little parenthesis on what you were saying about international engagement in the area of financial services. True, it's not the guts maybe, but there is a huge international engagement in standard setting bodies. And this is particularly important when we talk about concepts like equivalence and mutual recognition. Because if you can build on something which has been internationally agreed, then it's easier to use these tools of reliance on other jurisdictions. But okay, this coming back to my intervention today, what I would like to focus on is equivalence, which is one of the main tools of the EU uses to interact with third country jurisdiction in the area of financial services. And in particular, I would like to explain what is equivalence in EU law. I mean, very clearly, the concept has been explained. Maybe I will give some hints on what practically it means, whether it is a suitable tool in these times of geopolitical uncertainty. And I think my conclusion aligns very much with the one of Matthias. And finally, how we deploy these tools in the EU, so the decision-making process. And then I will briefly touch upon also the interplay of other concepts, mutual recognition, extraterritorial effect of EU legislation in our lawmaking practice. So to start, what is equivalence in EU law? It sometimes is described, and I would say somewhat inaccurately, as a market access tool. But primarily, equivalence is a prudential safeguard, is a tool to manage risk. as it was explained, the tool is about relying on the regulatory and supervisory framework of third countries when those are deemed comparable in outcomes to the EU one, meaning that they achieve the same results as the correspondent EU rules. And this includes effective supervision. And is a concept, as I was saying, very much linked to the effort the EU has been pursuing at the international level to encourage the development and the implementation of international standards globally, because this is the basis for this reliance. Yet, there is no single equivalence regime in the EU. There are different equivalence rules embedded in different pieces of EU legislation, and each piece of legislation tailors equivalence to a specific objective. It can be about reducing capital cost. It can be about enabling access to financial market infrastructure to facilitate cross-border trading, and potentially also to open a passport for non-EU firms. And the conditions that are attached to the equivalence, to granting the equivalence, reflect a bit this diversity. For instance, some equivalence decisions provide relief of prudential requirements for exposures of EU firms to non-EU operations. So this is, for instance, the case in the capital requirement regulation. So this is about less burdensome prudential requirements for EU firms operating in third countries. In other cases, equivalence reduces regulatory burdens by allowing firms to avoid complying with the double set of rules. This is what Matthias was underlining. And for instance, in the area of reporting and accounting, equivalence allows non-EU institution to meet the disclosure and transparency obligation or use accounting standards in accordance with the equivalent jurisdiction they are established in. In limited number of cases, equivalence regimes enable also, is a kind of market access tool. It enables the provision of services in the EU by third country providers under the same condition applicable to EU service providers. And this is the case, for instance, as it was mentioned, of EMIR, where the European Market Infrastructure Regulation. I mean, I was told that I shouldn't use acronyms, but here I would assume that you know what I'm talking about. So this equivalence regime allows the possibility for third country central counterparty to operate, to be recognized by the European, by ESMA, the European supervisory authorities in the field of financial market, capital market, and to be used by EU trading venue and clearing members at the same, in the same way they can use EU trading venues. So this is in a way similar possibilities are also present in other cases, for instance, for the credit rating agencies, where you see there is a dimension of relying on the supervisory framework of other countries, because, for instance, credit rating agencies, if they are established and supervised in an equivalent third countries, they are recognized also in the EU, and the ratings can be used as we use EU ratings. So these are different ways of shaping, designing the equivalence regimes, but at the end, the objective is always the same, is to have is a tool that allows to have a cooperation with third country partners to promote fair, efficient, and resilient financial markets by encouraging the uptake of sound regulatory standards, and to open up business opportunities for both EU players and third country players. So in that sense, is a mutually beneficial tool. And is that tool suitable? Coming back to the second element of my presentation, is a suitable tool in the current geopolitical context? I think that with the more than 300 equivalence decisions the EU has taken across sectors and jurisdiction, we have seen how important is this tool to manage the external dimension of EU financial services policy. For the business, from the business perspective, it's useful because it enhances the cross-border business conditions, so it facilitates trade. From the public authorities' perspective, it can serve as a mechanism to promote high regulatory standards globally and strengthen international cooperation. So with equivalence, you can reward those that align with sound standards by eliminating duplicative requirements. And I think that so far this tool has proven to be a valuable tool to facilitate market integration, while at the same time safeguarding financial stability, encouraging regulatory convergence, and fostering cooperation. Now, as it was underlined, importantly, equivalence is unilateral and discretionary decision. In the EU framework, there is no obligation to grant equivalence. In some free trade agreements, there are provisions, but only obliging the EU to assess equivalence, definitely not to grant equivalence, which is a discretionary decision. So it's not a country don't have a right to get it, and it's not automatic. Also, by definition, is a revocable decision. It may be granted in full or partially for an indefinite period or for only on a temporary basis, and may be subject to specific conditions. This makes this tool suitable for cases where you need to see how a third country framework works and how it evolves. So in any case, the equivalence may withdraw if the conditions are no longer fulfilled. And this is also why in the recent years, our focus has been very much in monitoring equivalence conditions. So we have strengthened the role of the European supervisory authorities in this respect to make sure that once we grant equivalence, then we are also able to monitor that the conditions are fulfilled and act if they are not. So I think to conclude that equivalence these characteristics makes equivalence a suitable tool for times of geopolitical uncertainty, where the third country frameworks may evolve somehow unexpectedly in a way that do no longer ensure the result that the equivalence is intended to achieve, and thus affect the trust that should underpin this decision. So, is a suitable tool. How this tool is deployed in the EU. The Commission policy on equivalence in financial services was set out in a communication of 2019, which I want to refer to because it underlines two important elements that are still very valid. The first one is that equivalence is an outcome-based exercise. So it's not a line-by-line comparison, but this looks at whether the outcome is the same, the result is the same, and that it's useful in a world where it would be ideal to have the same standards, but we don't. Second, importantly, in relation to the autonomy concept, equivalence must serve EU interests, including financial stability, investor protection, and market integrity. This communication adopted after Brexit puts equivalence in a broader context. For sure, it has to be based, the equivalence decision, on a solid technical assessment and in accordance with the criteria that are set out in legislation. This is essential, that we stick, it is solidly grounded. At the same time, equivalence this involves a political judgment. An equivalence decision should be compatible with EU external policy priorities. Why? Because positive equivalence, in fact, demonstrates that the EU is prepared to forge a closer relationship with a third country and to trust its institution. So this is why equivalence needs to be compatible with policy priorities in areas such as international sanctions, fight against money laundering and terrorist financing, and so on. And these are factors that, although they are not linked to the specific criteria, are indicative of the risk that may affect financial stability, market integrity, and the protection of financial market participants in the EU. So the decision-making process reflects these two dimensions. The technical assessment is performed on the basis of technical advice for the European supervisory authorities and may involve some dialogue with authorities of third countries to make sure that the assessment is solidly grounded. Then the decision is taken by the Commission at the level of commissioners, so which take into account also the strategic dimension, and typically takes the form of an implementing act, sometimes a delegated act, which implies also some form of scrutiny from member states, from the co-legislator. So equivalence is not a purely technical tool, but has also a strategic dimension. And I think this is important for the challenges that the current geopolitical context poses. Briefly, very briefly, difference between equivalence and mutual recognition. As it was said, equivalency, to sum up, it can be seen as a conditional openness, while mutual recognition is deep trust. So in the EU, we have built the single market on mutual recognition, but this is hard to replicate externally because it implies not only high level of convergence, but also similar supervisory practice and an enforcement and dispute settlement mechanism. So that's why mutual recognition agreements are rare, and the EU has relied on equivalence, which compared to it offers flexibility and control, and it is much easier to deploy. Few final words on extraterritoriality. I agree, is the notion blurred, so I would just recall that in principle EU rules apply only to within the EU, but there are cases where the scope goes beyond the borders, but this occurs only when the EU non-EU entities engage in activities with a clear nexus to the EU markets or financial system, and where those activities pose material risks. So that's where I agree there are cases where extraterritoriality is necessary for a prudent management of our financial markets. Let me just conclude with three considerations. The first one, as I said already, in the EU, equivalence remains a suitable tool to deal with third country partners, but the other concept can be used in an external strategy, can be complementary. The thing is to find the right balance, so to get right the balance between reliance and imposing our rules. Second is strategic agility is essential. Financial market evolves faster than legislative cycles, and geopolitical conditions can shift suddenly. So it's essential to have a tool which is agile and can respond to this moving dynamics. Third one, and I would like to conclude with that and to underline, international cooperation remains essential, both at regulatory and at supervisory level. So I think that our effort, even these times, should be to maintain this international cooperation to encourage convergence and reduce harmful fragmentation. And I will stop.
Thank you very much, Maria. I think I've certainly learned so much about how generally your system works, and it does seem to work. Over to my left, to George. Yeah.
Matthias, may I have the... Good morning, everyone. It is a pleasure and honor to be on this distinguished panel this morning and to be able to speak at this year's ECB Legal Conference. And thank you very much, Chiara, for the kind invitation. So the topic of this morning's discussion is on the cross-border interaction of legal systems and the importance of international cooperation. And this is particularly important, I would say, and particularly relevant to the issue of dealing with the failure of a large, systemically important bank, which is going to be the focus of my talk today. In this kind of crisis situation, the stakes are clearly high. We saw the financial crisis in 2007 and 2008, and after that crisis, the then governor of the Bank of England, Mervyn King, coined this well-known sort of phrase that large, complex financial institutions are global in life, if not in death. So what he was referring to there was the experience that we saw in that global financial crisis. So while solvent, clearly major banks operate across multiple jurisdictions, but in the event of a bank's failure, it does fall to national jurisdictions, or it did fall to national jurisdictions, to manage the resulting disruption. As we saw in the crisis, either national governments had to bail out a bank's local operations, or else those local operations would fall into national insolvency proceedings, which of course were disruptive to financial stability and the continuity of critical financial services. Following the financial crisis, jurisdictions developed what we call resolution regimes, which are a set of powers given to a resolution authority to manage the failure of a bank in a way which promotes financial stability and reduces the need for the use of public funds. So, for example, authorities now have powers to direct the transfer of a business of a failed bank to a private sector purchaser or a temporary bridge bank, or to recapitalize a failed firm by bailing in their liabilities. However, in designing these regimes, this issue of banks being global in life, if not in death, is still relevant. And it goes to this sort of key legal question, which is, how do those resolution authorities ensure that the resolution actions have legal effectiveness when applied on a cross-border basis? So what happens if a resolution authority is trying to bail in a liability governed by foreign law or transfer an asset located in a different jurisdiction? So my talk today, I was going to take you through how international and national authorities have sought to address this question over the last 15 years or so. We'll look at the sort of relevant international standards. We'll also touch on how resolution authorities have been looking to reduce legal uncertainty through the design of resolution strategies and contractual mechanisms. We'll look at the statutory frameworks for recognition of resolution actions within the EU between member states, and also the UK's regime, drawing on a recent case involving a Ukrainian bank. I'll also be touching on some cross-border regulatory issues which arose in the recent failure of Credit Suisse before offering some concluding remarks. So, firstly, the international standards in the space. So following the financial crisis, the Financial Stability Board, the FSB, developed international standards for effective resolution regimes, which is sort of equivalent to the Basel regime which we have for banking supervision. Now, these international standards recognize this issue of how do you ensure, or the challenge of ensuring the legal effectiveness of resolution actions in a cross-border context. And it sought to address this in sort of two ways. Firstly, a really strong encouragement for cooperation, and the international standards there provide that the resolution authority should have a mandate to cooperate with other authorities. But critically, in Key Attribute 7.5, the international standards provide that jurisdictions should provide for legal mechanisms to legally give effect to a foreign resolution action in their own jurisdiction. In a moment, I will sort of take you through how the EU and the UK has sought to implement these key attributes. But before doing that, I also wanted just to say a few words of how, even in the absence of such regimes, resolution authorities have sought to improve the legal effectiveness of resolution actions. So for most large, systemically important banks, resolution authorities have designed what's called a single point of entry resolution approach, where they will take resolution action or apply bail-in in particular at the top level of the group. In particular, for example, a holding company. Now, a holding company will not have any sort of operational assets or liabilities such as loans and deposits, but will issue debt and equity on behalf of the banking group as a whole. So by applying resolution powers in a targeted way at the holding company, that reduces the amount of cross-border elements that resolution has to address. So resolution under this sort of strategy, resolution powers don't need to be applied at the level of each operating bank within each country. There's no transfer of assets or liabilities, for example, between the different countries. So the two main kind of foreign law legal issues that arise under this strategy is where a particular bank has issued liabilities governed under foreign law, and there's a question, how would the bail-in be effective in that case? In addition, in resolution authorities will seek to ensure that the financial contracts, for example, ISDA documentation, which banks may have entered into, are not, events of default are not triggered under those contracts, and they will typically impose a stay on any termination rights. Again, there's a question, how would it work? How would that stay work where the financial contract is governed by foreign law? So one of the ways in which resolution authorities have sought to address this is by mandating banks to include contractual recognition clauses. So in the case of debt issued to foreign investors, the investors agree in advance to be bound by any future bail-in. And likewise, in relation to financial contracts governed by foreign law, the counterparties would agree to be bound by any stay in resolution subject to certain conditions being met. And the general expectation is, as a matter of private contractual law and freedom of contract, that a court should be able to uphold such contractual provisions, given that the parties by definition have consented to these arrangements. However, they have not been tested in case law as of yet, and the FSB have emphasised that while these are workable solutions, it does not do away with the need for statutory mechanisms as called for in the key attributes to ensure that resolution authorities can formally and legally give effect to resolution measures from overseas. So how has the EU implemented these sort of key attribute international standards? And I would say the EU really has led the way in this space when it drew up the Bank Recovery and Resolution Directive. It there provided for a regime for recognising resolution actions between EU member states, which is what I'll touch on, but also recognising resolution actions from third countries. In terms of resolution actions within member states or between member states, the BRRD amended the Reorganisation and Winding Up of Credit Institutions Directive to effectively provide for automatic recognition of resolution actions between member states. Now, these provisions were actually put to the test in this Novo Banco case, which was heard in the UK Supreme Court in 2018, while, of course, the UK was a member of the EU. Now, this case involved the failure of a Portuguese bank, Banco Espírito Santo, BES. And what had happened in that case is the Central Bank of Portugal had resolved the firm, transferred some of its assets and liabilities to a bridge bank called Novo Banco. Now, there were some loans governed by English law, which initially had been thought to be transferred to the bridge bank, but subsequently the Central Bank of Portugal issued an administrative decision clarifying that actually they were not transferred and would therefore be exposed to loss in the insolvency of BES. The creditors under that English law, under those English law loans, challenged the decision and effectively said that this sort of Portuguese administrative decision should not qualify for automatic recognition under the EU regime on the basis that such clarificatory decisions were not within the scope of the BRRD. Now, while initially the English High Court agreed and took a very sort of narrow interpretation, this was overturned by the UK Court of Appeal and the UK Supreme Court. And the Supreme Court ultimately decided that what the BRD and the Credit Institutions Winding Up Directive are trying to do is to provide a high degree of legal certainty, to provide for a universalist regime whereby there should be a centralized process. And therefore, even though the particular action was not provided for in the BRD, given it was effective as a matter of Portuguese law, it should therefore be effective as a matter of English law. And therefore, the decision was given automatic effect within the UK. So now to look at the regime in the UK, which was adopted when the UK was part of the EU. We implemented a framework, a statutory framework for the recognition of third country resolution actions. This was retained after the UK left the EU. And essentially, the UK framework provides a presumption that non-UK resolution actions would be recognised in the UK, subject to certain exceptions. The regime provides the Bank of England as the resolution authority with the powers to make the recognition decision with the approval of the UK Finance Ministry, the HM Treasury. And that's because this obviously involves questions of international law, and resolution, of course, can involve fiscal considerations as well. Now, in terms of the test which the Bank of England needs to apply, it's essentially a two-tier test, which involves two sort of key questions. Firstly, the Bank of England is required to assess whether the third country resolution action which it's being notified of is broadly comparable to what would have been expected from a corresponding action in the UK in terms of the objectives and anticipated results of a resolution. And then the Act requires the bank to recognise this decision unless certain exceptions are met. And I won't go through all of them, but these include, for example, where recognition would have an adverse effect on UK financial stability, or if it would be discriminatory to UK creditors. Now, this recognition regime was put to the test in 2021 when the UK authorities were notified by the National Bank of Ukraine of a bail-in of Privat Bank. Now, Privat Bank was a large retail bank in Ukraine. In 2016, it became insolvent and it was actually nationalized. But as part of that crisis measure, the Ukrainian central bank had bailed in a number of liabilities, including $600 million worth of loans issued to international investors via UK special purpose vehicle. So when we were notified of this decision, we were required to analyze the resolution and apply the test, which I'd set out. And we did find that the resolution was broadly comparable and that none of the conditions for refusing recognition were met. So as a result, after consulting various stakeholders, including creditors and the National Bank of Ukraine, the Bank of England issued a resolution instrument which effectively gave effect to this bail-in as a matter of English law. And one key sort of lesson I wanted to highlight from this case was the importance of international cooperation, which is again the theme of what we're discussing here. We had a very sort of detailed notification and information from the National Bank of Ukraine, but we had a number of follow-up questions because we needed to get a detailed understanding of the regime in Ukraine, which was essential. Now, before concluding, I was going to make a few observations on the recent failure of Credit Suisse, which also raises some issues in terms of having to think about implications for cross-border cooperation in the resolution context. So as you're all probably aware, in 2023, Credit Suisse experienced severe financial difficulties, and FINMA, the Swiss Resolution Authority, made advanced plans to apply bail-in to the top of the Credit Suisse group. In the end, those resolution plans were not needed due to the UBS's acquisition of Credit Suisse, which was, of course, facilitated by the Swiss authorities. But there were some learnings that came out of that kind of advanced planning which took place ahead of the failure of Credit Suisse. And these were detailed by the FSB in their October 2023 report on the banking failures in that year. And the issue that I wanted to highlight was actually during the kind of resolution planning, it came to light that there was particular issues around ensuring that debt issued by Credit Suisse in the US needed to comply with US federal securities laws. In that sort of advanced contingency planning, the SEC, Securities Exchange Commission staff, highlighted that the bail-in would have effectively required the issuance of a prospectus in the US on the basis that, in their view, the bail-in and the offering of equity to those bailed-in investors constituted an offer or a sale. Now, this is different to the position generally accepted in the UK and I believe in the EU. And the SEC noted that this would require quite a lot of detailed work for a failed firm to produce a prospectus over a resolution weekend. Following this, there is a lot of work going on in the FSB between the SEC and other market authorities to see what can be done with firms in advance as part in sort of peacetime planning to facilitate this in any future failure. And the point I really wanted to emphasize from this case is that there will not only be kind of legal issues that arise in a resolution, but cross-border regulatory issues such as this, which further emphasizes the need for regulatory cooperation and having a wide cast list of stakeholders. So to conclude, as I sort of set out, the failure of a major bank is a very complex process. It does involve significant areas of legal uncertainty in terms of how they can be affected on a cross-border basis. A lot of progress has been made in terms of international standards and statutory recognition frameworks that have been implemented in the EU and the UK and have been put to the test in cases such as Novo Banco and Privatbank as well. But a key point that I want to emphasize again is the importance of international cooperation, as we saw in the Privatbank case, as we saw in Credit Suisse case. It is an essential precondition to resolving a firm in a way that respects financial stability, is to have that degree of cross-border cooperation. So thank you for your attention. I'm very happy to take any questions as well.
Thank you very much, George, for this particular specific case study on recognition of foreign decisions. I open up the floor for discussion. I think we still are broadly within time, so I don't need to balance your right to coffee with your experience at security earlier this morning. I will take 3 questions and then see what follows. Could you please say who you are and be concise with your questions 1, 2, and 3? Start on the left there, middle of the room.
Thank you, Jens Binder, University of Tübingen in Germany. I've got a comment and a question mainly to Matthias Lehmann. I certainly do agree with the positive assessment of equivalence, and I think that very much everybody in the room will agree to that. But I was wondering whether the assessment that you gave might perhaps a bit too idealistic. For one, I think equivalence is certainly not non-political. It is certainly political, and I think we've heard the reasons for that in the subsequent speech. I don't think that equivalence decisions will ever be made without political motives in mind. And secondly, isn't it wise, given the still not satisfactory state of affairs when it comes to the recognition of bank resolution decisions and similar decisions in other jurisdictions, to insist that foreign operations, to the extent that these are relevant for domestic stakeholders in particular, be carried out on the basis of intermediate holdings, which you can then ring fence in insolvency, because there's still so much uncertainty out there that it may simply be not enough to protect your individual territorial turf just to revoke equivalence decisions, you better make sure that there are sufficient amounts of assets which you have under control in certain third country relations. Thank you.
Thank you.
Thank you very much. Sophie Violodiniak from ESMA. And as ESMA was not mentioned, but EMIR was a couple of times. And given the fantastic composition of the panel with both regulators, well, central bankers, academics and commission, I wanted to maybe draw your attention and seek your insights or suggestions on two more practical points maybe. One is equivalence assessment is a tricky business, but it is doable as far as it concerns assessing the equivalence of a third country legal framework. It gets a bit more tricky when it is about assessing the effectiveness of supervision and enforcement by third country supervisors. Why is that so? Well, supervision the proof of the pudding is in the eating. So is it for supervision and enforcement. And also, when it comes to supervision and enforcement, you cannot pre-assess it point in time at the time of taking the decision of equivalence. So there's an inherent challenge here. One that, second point, we at ESMA had the pleasure to experience in practice, and that's in relation in particular to India. One specific element beyond the equivalence decision, and probably Commission was careful here, is also adding some extra layers of scrutiny. Beyond the equivalence decision, there is also in EMIR the duty for ESMA to adopt recognition decisions of third country CCPs. In doing so, there are a number of mandatory steps, including having in place, very sensibly, cooperation arrangement with the third country supervisors in charge. And among these specific points we have to assess, there is also that specific one linked to supervision and on-site inspections. These, for a number of third countries, no clue about the UK at the moment, but certainly can be perceived as extraterritorial in the very basic sense, and has the potential for really making things a bit more difficult further down the line. So I was just wondering, while on one hand it's very useful to have these additional safeguards to make sure that equivalence along the way remains a useful and relevant decision, any views on how we could make the whole system a bit more maybe palatable to our third country supervisors, while equally keeping some teeth in the system to make it truly relevant and useful? Thank you.
Thank you. And there was a question there.
Dalwinder Singh from the University of Warwick. And thank you for the informative presentations. On one level, CRD6 has created significant consistency of practice when it comes to third country branches. Yet equivalence essentially lies within the national discretion. So do you think that there is a need for further guidance, one, in order to bridge the supervisory practical gaps? And equally, should there be better consistency of practice from the supervisory also into crisis management when it comes to BRRD and also DGSD in terms of the crisis management framework also mirroring what has been extensively done on CRD6 in terms of practice?
Thank you. Thank you. Matthias, do you want to start?
Yes. So on Jens-Dietrich Binder's question, should equivalence be used politically? I'm reflecting on the discussion that we had in the literature. And as I recall it, most authors were of the opinion that the EU bodies should not have discretion in granting equivalence. And that's a little point of contention between me and Maria. So literature says the EU bodies are rule-bound. It's an administrative decision. And if the conditions are there, you should grant it. So it's not a political tool that we extend to friends and family. It's something that has to be granted when the conditions are there. And I'm of the same opinion, because I think it should not be withheld for unknown reasons. I may cite, although this is risky, the example of Brexit. We all know that the UK was 100% compliant with EU law after Brexit, and I think we still have no equivalence assessment. Is this wise? I'm not sure whether it would not be wiser to extend now a little bit of equivalence to the UK to make clear, if you now choose a different path and you burn the single rule book in the UK to become Singapore on Thames, then it will really entail a cost for you, right? At the moment, it doesn't entail much cost because they don't have equivalence anyway, although they are 100% compliant. So I would rather use this less politically and not get animosities that we have with the UK since Brexit in the way of granting equivalence. It should be an economic and a neutral assessment of the benefits of opening the markets and the risks that it entails. Now, when it comes to assets that we may need, I agree that, for instance, you could require a bank that they join the deposit insurance scheme and so on. But shall we require that we always have assets on our territory, as we do, for instance, in EMIR now? Even if you provide simple advice on crypto services, you have to be located in the EU. Is this really wise? Doesn't it lead to a fragmentation of the financial world where everybody has to have an office everywhere, capitalized and so on? It's absolutely contrary, I think, to the idea of global markets, and will not necessarily make things more efficient. Although I understand, of course, the tendency of the regulators and supervisors to want to have control over everything, we must be aware that this adds to the fragmentation of markets. When it comes to the question of the representative of ESMA, yes, on-site inspections, I think that's the clearest case that you can have of extraterritoriality. You send your officials to London to inspect a CCP, for instance. It cannot be more extraterritorial than that. That's why we got the agreement by the Bank of England to do that, and they gave it because they also have the interest of providing clearing services to the EU. Are there other possibilities? Well, you don't always have to inspect on-site, right? In most equivalence regimes, this is not foreseen. It's foreseen for clearing because this is so systemically important for us. But for others, we just rely on information that we gather from the outside, and we don't have to go in. Give it more teeth. I don't know how you would do it, perhaps through digital use of information instead of going there physically. So I'm at the end of my wits a little bit how to do this differently than either assessing it unilaterally from your turf or to go there. And for Javinder Singh's question about guidelines, yes, guidelines are always useful, and I'm particularly grateful, and I was in the preparation of this for the 2019 Commission paper on the use of equivalence. And I think it would be very useful if the ECB did the same thing for CRD6. Thank you.
Thank you. Actually, Raffaella, everybody calls me Raffaella, but okay, it doesn't really matter. No, thanks a lot. I mean, on the first question about equivalence is political. I mean, I want to be clear. I didn't say that equivalence is granted only to friends and not to foes, and the decision is led by random political considerations. But there are policy consideration which goes beyond the strict criteria, and while they don't affect the technical assessment, they might affect whether we want to grant equivalence to, for instance, a country which is listed by the Financial Action Task Force for severe money laundering issue. Do we want? And this is not because they are not friends. This is because equivalence is based on a relation of trust in the framework of the third country, in their institutions. So these are broader considerations than the purely technical ones. That's why I maintain that certain discretion is worth it, and it has to be used wisely, of course, but a certain discretion is worth it. Then on the question about EMIR and the extraterritoriality, I fully appreciate that assessing the effectiveness of supervisory practice is challenging. And I think that on-site inspection are a useful tool. Said that, honestly, the issues we are experiencing with India are not really on this. It's not about real risk of extraterritorial action, because as you know, in the EMIR equivalence framework, is an important point. There is an element of risk weight. You don't treat all jurisdiction the same way, but you look at what are the risks that their institution pose. And so that's why there is a tier system. Honestly, I don't see ESMA going to India to actually inspect the Indian CCP. It won't happen. So the issue is another one. The issue is how much palatable, as you said, is a recognition for the Indian? Probably not, because it is more in the interest of our institution operating there. So, and I think that the way out when we face this kind of problems, which are not legal, are purely political, I think, is regulatory dialogue and cooperation and dialogue, and to explain where we come from and to explain also that equivalence can be mutually beneficial. On the third question, yes, I fully agree. Guidelines are always useful. I mean, then our banking regime, I mean, from the European perspective, more harmonization in supervisory practice is always useful in intra-EU. That's irrespective of the external dimension. And I will stop here. Thank you.
Yeah, I just had a couple of reflections on some of the questions. I think one question was about the idea of ring fencing assets sort of locally. I think that is quite difficult for a large, complex financial institution to seek to kind of resolve it on a standalone basis, on a jurisdiction by jurisdiction basis. I mean, the business model of these large banks is that they operate across borders. And so that I think there'll always be a question of how viable a large bank would be if you're looking to ring fence some of its local operations. I think for smaller banks, it's a slightly different story. I mean, we saw this in the example of Silicon Valley Bank, which was a kind of a smaller US bank, which failed also in 2023. There, they did have a UK subsidiary, and we were able to resolve that subsidiary by transferring its business to HSBC over a resolution weekend. But again, in that case, cooperation was vital with the US authorities because the SVB subsidiary in the UK relied heavily on the SVB's parent in the US for critical services, and our relationship with the Fed and the FDIC was key in ensuring that those services would continue. And on the ESMA reflection about supervisory visits, I mean, again, that's something Bank of England is supportive of. Indeed, in our approach for recognizing non-UK CCPs, we have this sort of concept of informed reliance, and it goes back to what Rafaela was talking about in terms of the trust and how much trust you have. And I think the ability to do joint supervisory visits is obviously a key part of that trust and that informed reliance, which a supervisory authority can take.
Thank you very much. I think we have time for a couple more questions. Christoph had a question, and the person behind him as well. And then we'll conclude for coffee. And I thought we were going to enter Brexit territory, but we are still steering clear of that. That's a good thing, I think.
Thank you, Pete. Christoph Hermann, University of Passau. Maybe it would have been better if some of the panelists had mentioned the guts, jumping on the discussion about political or not political decisions on equivalence. I mean, the most favored nation principle in the guts applies regardless of whether we've made any market access commitments. So I would not like to defend the EU in front of a panel or the multi-party interim arbitration arrangement, having the other side quoting from this discussion here that there were several EU officials mentioning that it's always a political decision. I mean, MFN is, of course, difficult to apply to equivalence decisions because the equivalence between the equivalent regimes will sometimes not be equivalent or will not be given. But still, I think for granting it, MFN applies. For repealing it, of course, it applies again. And if you take it away, I would also see cases in the European Court of Justice, very interesting ones regarding Article 263, paragraph 4, maybe by the banks indirectly affected by the withdrawal of the equivalence decision concerning whatever country, and even arbitration cases coming afterwards, because, of course, a bank that has been working under equivalence decisions regarding its home country will possibly also have made an investment in the European Union. So maybe it's not that much a political decision only, but a political decision also bound not only by EU law, but also by the guts. So maybe we should appreciate the guts a little more than we sometimes do. Thank you.
Thank you very much, Nathan Darabasile, Rotterdam School of Management. I want to push you a little bit more, Matthias and Maria Rafaela, on this issue of equivalence, because I think Matthias rightly pointed out that the UK has very, very few equivalence decisions, while the US has the most equivalence decisions. And today, this political dimension may be tricky at the point where we are subjected to blackmail by the United States and others. So I was wondering to which extent was this strategic dimension also perhaps better suited if we were to adopt more multilateralism, rule-based order view of the equivalence regime and limit discretion in the political views that underlie it. And another point on the relevance and variations of equivalence, because of course we talk about equivalence like it is one thing, and there are many, many different equivalence regime. And I think we were mentioning the on-site inspections. It's not just in EMIR, it's also, for instance, for external reviewers of European green bonds, that we require equivalence regime where there is nowhere else this kind of requirements, and on-site inspections right for European supervisors. So the relevance of that is perhaps a little bit tricky, and there may be better requirements that the Commission and the legislature could think of to support EU standards. Thank you.
Thank you very much. I'd like to start.
Yeah, maybe I'm starting. I'm not an international lawyer, but to my knowledge, there is no hard guts commitment to grant equivalence to countries which so requires. So, and the most, but in dealing with different countries, yes, and we deal with different countries the same way. So, if the country requires equivalence, the assessment can be performed. Then this does not affect the discretion which the Commission has, the timing of this decision. And more importantly, I point out again, is not about random political willingness to grant a decision or not, is in a way also a policy consideration whether, as I was pointing out in the communication of 2019, on when it is in the EU interest. Otherwise, we can grant equivalence, I don't know, to potentially to all countries in the world, but it is worth. So that's also what we take into account when going for equivalence, what is the interest for European markets, either because we want third country players to come in and offer new services, better choice for consumers. So we want to facilitate the trade, or because we want our companies to go in third countries and to facilitate their life and operate with easier conditions. So there is this element of whether there is an EU interest to go for equivalence. It's not random political discretion, is based, is a policy decision. Now, I'm not entering into the Brexit, but I mean, again, also there, I think that the same principle applies. We go for equivalence when we see an interest. We did the one on clearing because there was a clear need, an interest, and for the stability of the European financial markets and for our businesses to have this decision. So we went for it. On the second questions, let me recall exactly. Which was about, sorry.
US,
Yeah.
granted too much.
Yes.
Then that's to the UK.
Well, landscape is changing. As you pointed out, withdrawing equivalence is not that easy because it has consequences. So one should think carefully when to grant and also when to withdraw. Now, what's happening in this world is, of course, that there are developments going here and there in different directions. What we still aim to is to maintain a dialogue around convergence with international standards, including with the US, which in a way or another now intends to implement Basel III. So with these foundations, of course, you can keep building on an equivalent system. Of course, we should be ready with the monitoring that I was mentioning to assess whether the conditions are really no longer fulfilled and there are important risks imported in the EU that we have to face. But withdrawing is also not an easy decision and has to be carefully thought through. And I think I will stop here.
Yeah, just very briefly because of the coffee break. I fully agree with Christoph Herrmann. Most favored nation clause applies under GATS. There is the regulatory carve-out, of course, but I have always been arguing the regulatory carve-out should also not be applied discretionarily and differently to different nations. Of course, if you say, well, this rule is safe, then you also have to apply that to others. So the regulatory carve-out, although it's a carve-out, also has to respect most favored nations, I would say. But I'm not an expert on GATS. With regard to the other question, well, of course, if a country doesn't respect AML and so on, then the conditions of equivalence are not there. But if they are there, I think equivalence must be granted. And on that basis, it should have been granted to the UK before the US, had the UK not exited later the European Union. To Nathan's question, sometimes it's true that the conditions cannot be fulfilled because other countries don't have an equivalent regime, green bonds, right? But what is even worse is when the EU adopts an act without an equivalence regime, as it did with EMIR. Simply suppose that nobody will ever have an equivalent regime, so let's wait for it, and they only have a reporting requirement for the Commission to introduce it, perhaps in 2027. I think every act should have such a thing. So maybe as a way of seeking consensus with Rafaela, we could say, when assessing equivalence, of course, you have to set priorities because you only have this time-consuming and you only have so much stuff. So if a very small island now demands equivalence, may be very difficult to assign people to assess this country, this framework. So you have to set priorities. And of course, you start with the big trading partners. That I completely understand. And in that sense, you have a wiggle room. But if the conditions are there, I think, and you have the staff, then I think over time you should extend it to more countries.
Thank you very much. It's all been very interesting. If I can just add a few words. I mean, I think this discussion now at the end on the discretionary nature of granting equivalence is not different from any other area of law where there is discretion, and discretion is never absolute, of course. And that's, I mean, if I can link it with even with the speech by Susanne Beer yesterday at the end of our session, this is all about the rule of law, and it's all about kind of looking specifically in detail, technically, with legal concepts at how law operates in this area as much as any other, I think. I hope you will join me again and thanking the speakers in the usual way, and invite you for coffee outside.